A Scottish judge has allowed hundreds of Kenyan farm workers to take legal action against one of the world's biggest tea producers. The workers are current and former employees of Finlays, a multinational company which was founded in Scotland in the 18th century. Well, for a little bit of analysis on the judgment, we're now joined by advocate Evans Ogada, who's a researcher and associate editor at the Platform for Law, Justice and Society. Thanks so much indeed for joining us, Evans. Welcome to the program.
Thank you very much, Peter.
How significant is this judgment, especially when we consider jurisdiction and, where these suits are filed and where the crimes, inverted commas, occur?
Well, this is important because Scotland only recently, as recent as 2020, that's when Scotland had its first class action suit. So Scotland does not have a history of class action suit, what they call group litigation. Now, for the court to have deemed the claims by Kenyans worthy of its attention is quite a huge statement.
All right, so let's talk a little bit about the merits of this case now. The workers are claiming that the conditions that the workers had to work under were hazardous to their health. And I just wonder, when we start talking, especially things like labor laws, are they fairly universal? Is there a minimum standard that must apply anywhere? Or how might this case be looked at? Well,
we have certain basic principles on labor laws. Your viewers should be aware that we have so many treaties governing worker rights and worker protection within the aegis of the International Labour Organization. So certainly we have shared norms, shared principles that ought to govern workers internationally. Now, I believe, and it is my an opinion I hazard, that perhaps these workers went to file a suit in Scotland because they were likely to get much more in terms of compensation. What they will have got here in terms of compensation is statutorily restricted. If you look at our labor laws and what they could get under the employment and labor court, a little bit restricted. Perhaps they went to Scotland with the belief that the courts over there might be more generous than perhaps what they would have got from Kenya.
All right, this is reminding me of a case recently where Shell were taken to a court in The Hague in the Netherlands about operations in Nigeria. And the courts in Netherlands said, yes, no, you are accountable. I wonder, because their head office is in the Netherlands, Finlays is a Scottish company, and so perhaps because the head office or the holding company is based in Scotland, that might be a good reason to take it to Scotland. But does that then mean it will be tried under Scottish law as opposed to Kenyan law?
Well, from the Kenyan case is wording that would connote a case in what we call torts, civil liability for harm on Kenyans, not necessarily labor law. So the principles for torts are more or less close to what we have in Scotland as in Kenya. The connection, yes, certainly is there because of the very fact that Finlay is headquartered in Scotland. So there is a connection between Finlay, by virtue of being a quote-unquote citizen of Scotland, vis-a-vis the claims that these Kenyans will be seeking to address the court about.
What do we know about what actually happened to the Kenyans? Is there enough evidence to show that some kind of damage was suffered and that there should be some liability?
Well, from what they presented before, because for you to satisfy the court that we have a viable group action suit, you have to present what we call a prima facie case. There should be a little bit of evidence to satisfy the court that your claims are not frivolous. So from what Lord Justice Weir in the leave stage, the leave stage is the stage where they were seeking the authority of the court to be heard. Certainly I've seen evidence of people presenting evidence and stories of them having back problems and myriad of health issues, because these people were made to work for 12 hours, carry as much as 30 kilograms, and used to work for 6 days a week. So you would certainly expect the solicitors who are representing them, the firm of Thompson Solicitors, who are representing them, certainly should have done their groundwork and collected enough evidence.
Does this set a precedent, I think, for global companies that are headquartered in Europe with operations in Africa who perhaps don't have great records historically, that they may actually find themselves with these kinds of class actions to follow what's happened to Finlays and maybe even Shell?
Yes, certainly. We've had the unfortunate stories in Africa whereby you can come and bribe a judge here and there, and you can prolong and really defeat justice, so to speak. But when you go to the more mature democracies, some of these shenanigans are not going to happen. So the confidence and the near pristine justice systems that are in the West will certainly be taken advantage of by litigants who feel that multinational companies have had the luck or had the mischief of getting away with some of the atrocities they commit in Africa.
I mean, these accusations that we're talking about, working 12 hours without a break, people getting injured whilst at work and not getting assistance, this sounds like slave labor, actually. And I just wonder if there isn't going to be reputational damage for a company like Finlays, who has Starbucks as one of its clients.
Definitely. And the globe is getting more social justice sensitive, so that it only takes such a negative story as this for people to boycott your products. How are you treating your workers? Where are you sourcing your products from? How are you dealing with those that are responsible for you to get the kind of crazy profits that Finlay has been getting? So yes, there's going to be some backlash. What I suspect Finlay to perhaps want to do will be to quietly settle this, so that when they settle this quietly behind the scenes and sign on some non-disclosure agreements, then the horrible stories will not filter out in the press, so that they would perhaps in that manner be able to mitigate the negative publicity that comes with such cases.
Are we just sort of, I don't know, looking at the tip of the iceberg here, do you think, because I'm just thinking that, back in the day, a lot of these companies came to our continent and they were not held to account because partly colonialism and also local authorities were almost beholden to these investor companies that they couldn't take action against some of these poor practices.
Yeah, certainly. You were absolutely right. These multinationals, due to the influence and power that they wield, have been getting away with basically anything in Africa. You gave the example of Shell. Shell has been accused of all manner of atrocities in Nigeria. You remember the death of Ken Saro-Wiwa sometimes back in 1995. Shell had whispers surrounding it in terms of how it condoned the excesses by the Abacha regime. We've had multinationals accused of all manner of practices in DRC Congo. So yes, these the Finlay case will just be a tip of the iceberg, and perhaps would push much in terms of civic engagement for we Africans to start asking questions of these multinationals.
Evans, we're going to have to leave it there for today, but thank you so much. Always good having you on the program.
Thank you very much, Peter.
Thank you. All right, that's Advocate Evans Ogada, researcher and associate editor at the Platform for Law, Justice and Society, talking to us about this challenging case that Kenyan workers have got some hope to try and get some compensation. Just to give you an idea of what we're saying, they were said that they were forced to work 12 hours a day, 6 days a week, without a break, all for around 2,000 Rand a month.